is it a good idea to put an arbitration clause in here? Should they, or does it not matter in the long run?
So, as with most things in litigation, specifically in commercial litigation, it depends on the facts, right? Like litigators, we work with the facts. We try to understand what their industry is. A different industry may want an arbitration provision, especially if, for example, they're in a very complex and very novel industry. Like, for example, I deal a lot with solar renewable energy, the trade of solar renewable energy credits. They're tradable commodities, right? Natural resources. And that is a very novel industry. And there's not a whole lot of law on it. And if I have to talk about this kind of thing to a jury's going to fall asleep. But if you can get an arbitrator who specifically worked in this industry, who understands what's going on, I think that's a perfect opportunity to have an arbitration provision in there, because then you can kind of at least have a better, or you have less uncertainty, I would say.
Yeah, I mean, through that decision when you're putting together an agreement, I mean, you're trying to guess the future a little bit. I mean, you could, depending on the dispute, maybe you wished you were in front of an arbitrator or a judge. But you're right. I mean, arbitrators, you have to pay them like you pay their lawyers. The judge, that he gets paid by the taxpayers. So the access to the court tend to be viewed as cheaper. And you could, in your agreement, you could say, well, we just want a judge and not a jury trial. You could say that you want a judge and jury trial, or you could say, we want an arbitrator. And, depending on the agreement and the preference of the client, I'm surprised to hear that they come out in different scenarios. But in certain situations where maybe it's not novel, maybe you don't need to have a subject matter expert ruling on the decision. And honestly, maybe you don't want to necessarily get into it. You're trying to get a deal done. A lot of times you'll just pick court, and then you'll pick the location and you'll move down the road. And I've seen in the middle of a litigation, sometimes if you have two good attorneys on both sides that are willing to work to each other, they can start agreeing on how they're going to resolve the dispute, and all of a sudden decide, no, we're going to go to arbitration. Yeah.
You were talking about a bench trial versus a jury trial. Generally speaking, what are the pros and cons of each?
Well, so I think one thing you may want to assess, or it's a little difficult for a client to do this, but a commercial litigator or just any litigator in general can assess the credibility of your client, whether or not they're likable, right? I think that makes a big difference. A judge is probably not going to care as much about that as a jury, right? A lot of times juries fall asleep. They're not going to listen to what's going on really, and they just make decisions based on who they like better. And a lot of times it's also based on how simple your side of the story is, right? If your case is more simple, you probably would want a jury. And if your case is a little more complicated, I think maybe you may want a judge. You would prefer a judge. The only but the thing is, like, judges are not really subject matter experts either, right? But at the very least, they do know the law a little better, right? Or a lot better than juries. And if you have a very strong like legal claim as opposed to a factual claim, then you would prefer a judge. But I think Jack brought up a good point. It's not just about picking whether or not you want arbitration. Sometimes it makes a big difference what jurisdiction you choose as well, right? I have a case right now I'm going to go to trial on in a month from now in Massachusetts, and this is one of those things where the other side's attorney were able to manufacture a way to renege on their agreement. Here's the problem: Massachusetts is the only state in the United States that does not have anticipatory repudiation. So it's very difficult to make that claim, but that's something that they should have thought of when the parties decided on the venue of the contract, right?
So speaking of venue, correct me if I'm wrong, but you practice at the federal level as well, right? In the federal court?
That's correct.
So what are some differences between the federal courts and the state level?
Well, I think the judges are probably a little bit different. Federal judges are appointed. state court judges, at least in Texas, are elected officials. They're they're essentially politicians, right? But I would say, like, structurally and in terms of format, it's a little bit less forgiving, right? If you miss your deadlines, it's a big deal. You have to follow certain formats. Judges have local rules in federal court. You have to follow, like, things like motions have to be double spaced. Motions have to cannot have footnotes that are too small. Things like that. Sometimes you may have to request permission before you can even file a motion. Those are things that, unless you're practicing in that jurisdiction, you're not going to know, which is why sometimes we will hire, like, local counsel if we have to go and file a lawsuit somewhere else. Even if we end up arguing those cases, ultimately, local counsel would advise us on kind of procedurally what we need to do to get there.
Information contained in this podcast and accompanying video have been derived from sources believed to be reliable. This content is not guaranteed as to its accuracy and does not purport to be a complete analysis of the topics discussed. Analysis is based on assumptions that may not come to pass. None of the content should be construed as legal or investment advice. You should consult with a qualified professional before implementing any strategies discussed. All expressions of opinion reflect the judgment of the speakers on the date the video was recorded and are subject to change.